Members, welcome back to the third session for today's one-day workshop on FEMA. To dwell upon the topic leveraging cross-border funds as loans or ECBs, redressal mechanism including appeals and compounding. We have CA Advocate BG Chidananda sir with us. Can I call upon CA Kavita, our treasurer, to escort speaker onto dais and then welcome him with floral bouquet. Thank you, Kavita. I have privilege in introducing today's speaker. BG Chidananda is a fellow member of the Institute of Chartered Accountants of India. He is practicing as an advocate. He has completed his law from Bangalore University. He is practicing as a lawyer for last 2 decades. He had initially practiced as CA Chartered Accountant initially for 6 years before choosing practice advocacy. He is representing matters in the areas of central excise, customs, service tax, and GST. He is also specializing in the field of foreign exchange management law, money laundering cases before various departmental authorities, tribunal, and courts. He is a co-author of a commentary on Foreign Exchange Management Act 1999. The first edition was published by Wadhwa & Co. He was also a collaborating author on Guide to Central Excise Law and Practice by Arvind P. Datar and B.N. Gururaj for their earlier editions. With this brief introduction, I present before you CA Advocate BG Chidananda sir. Over to you, sir.
Thank you. I thank the Institute for giving me an opportunity to talk on our area of expertise, that is the dispute redressal mechanism. If you ask me to talk about core FEMA, I'll find it very difficult because the brass tracks of FEMA is not something which I'm practicing. The procedures is not something which I practice on. I only practice on the litigation side of. Now, we'll see the overview of Foreign Exchange Management Act, how this law came into this stage now. The foreign exchange control was introduced way back in 1939. And after the independence, you had the Foreign Exchange Regulation Act of 1947. Then came the Draconian Foreign Exchange Regulation Act of 1973. Why I'm telling you this is that we need to know the background of the law if you have to know about the compounding or the adjudication mechanisms under the Foreign Exchange Management Act. Foreign Exchange Regulation Act was a draconian law because it is a criminal offense that if you violate the provisions of the law, what would have ensured to you was the prosecution, that is jail without bail. As far as the Foreign Exchange Management Act is concerned, this has become more of a civil law. Why it's a civil law? What would turn out as a consequence when there is a violation of this law is only penalty. The core provision now is Section 13 of the Foreign Exchange Management Act. Now there is a new iteration, which there is the latest amendment which has been done to Section 15 and also Section 37A, which was inserted. In case of foreign assets, if somebody has acquired a foreign asset outside India in terms of foreign exchange or foreign currency or foreign security or a foreign property, and with that, if that has not been declared by such person, and if that amount exceeds 1 crore, then there is a prosecution, which means that there is a jail time of more than 5 years. Only in that eventuality that somebody acquires a foreign asset and doesn't report it to the authorities, and if the amount involved is more than 1 crore, now that you have one small segment of the violation to be proceeded or prosecuted as a violation for which there is a criminality and for which you are liable for the criminal prosecution. Otherwise, FEMA does not have the prosecution. There is no jail. It's all about civil consequence. It's all about imposition of penalty. So, as we see the preamble itself clearly says, when we read the Foreign Exchange Regulation Act, the preamble says that the main purpose was to conserve foreign exchange. Now, the purpose and intention has completely changed to management of foreign exchange. Now, there is no longer conservation of foreign exchange. It's only about management of foreign exchange. And now, the core principle of Foreign Exchange Management Act is that the transactions are divided into two broader categories. One is on the current account, the other is on the capital account. So, what is the thumb rule? The thumb rule is that any transaction on a current account is permissible to be done until unless you have a restriction which is placed under the current account rules. So, this is the first thumb rule. The second rule is any transaction on a capital account is prohibited to be done until and unless it is specifically provided under the Foreign Exchange Management to be permitted to be undertaken by you. So these are the two thumb rules. Earlier, this type of categorization was never there. Earlier, the law provided every single transaction either to be done or not to be done under your exchange control laws by way of various circulars, ADMA circulars and exchange control manuals. The manual used to be 2-volume manuals where we started our practice, where we used to find out whether any transaction for that matter, whether is there any reference to that transaction, if the permission is given to you or not. So that was the situation earlier. Now, the law is completely changed. So in that context, the first step, I've given you the comparison of the Foreign Exchange Regulation Act with Foreign Exchange Management Act, which I've already. Now, who's given the absolute authority to administer the Foreign Exchange Management Act is the Reserve Bank of India. As Vivek sir was telling that for whatever doubt you have, the go-to authority will be the Reserve Bank of India. So here as well, the RBI has given powers to compound the violation and also the powers to administer the law, to give a lot of clarification. Now, RBI has given powers to issue master directions. RBI has given powers, two types of powers RBI has. The central government will frame the rule for a capital account transaction. How will the central government frame the rule? In consultation with the Reserve Bank of India. And what is the requirement for consulting the Reserve Bank of India? Because these restrictions, which is on a capital account, should be in public interest. You can't just like that impose the restriction. Today you have permitted certain transactions. Tomorrow you can't automatically impose a certain restriction. So they themselves have written this in the rules that any current account transaction, it is permitted in consultation with the Reserve Bank of India. There again, the restrictions will be imposed. So in all these situations, where central government has got powers to restrict the capital account transaction, and also they have got powers to regulate the current account transaction, RBI has to be invariably consulted. So the absolute authority is with the RBI. As you know, the very old case of LIC versus Escort, where Supreme Court said that RBI has got absolute authority to administer the law of foreign exchange. It still holds good. What did the Supreme Court say in LIC versus Escort was that when there a word or an expression permission is written in your law, it is not. It doesn't mean that prior permission has to be obtained. Only when the words prior permission is used, then you have to go to the RBI and undertake a transaction. if you undertake a transaction and if your law says a permission is to be obtained from the RBI, RBI can still grant a post facto approval or a permission which still amount to a permission. And this concept is still holding good now because I will again relate it to the compounding regulations. What does the compounding regulation say broadly? When you can go for compounding, it says that if there is a violation, and if the violation has to be regularized either by the central government or by the Reserve Bank, until and unless you secure the regularization or the permission from those concerned authorities, either the Reserve Bank of India or the central government, without taking the permission, you can't file a compounding application. I have a peculiar problem now. In one of the cases where you can relate well, that income tax raids was conducted and somebody had foreign currency more than $2,000. He had $20,000 in his house, and he used to travel so frequently that he used to really find it difficult to buy foreign currency every time he goes abroad. So he was traveling so frequently. But the law says beyond $2,000, you're not supposed to hold it with you per person. If you have 4 family members, you can say that 2,000 multiplied by 4, this much of foreign currency, you can hold it, no questions asked. You don't need to give any explanation for the $2,000. Now, this $20,000 has been confiscated by the income tax authorities, not by the ED. Now, there is a violation. I have made a compounding application saying that I'm holding $20,000. I'm having this explanation saying that I purchased these dollars at so and so date, so I can give an explanation to you, compound this. My compounding application is returned, saying that the investigating authority, the income tax, take a no objection certificate from the income tax authority. How can I take it? And from the enforcement directorate. Where is it possible that enforcement directorate, without even commencing the investigation, gives me a no objection? Because they say any investigation which is commenced against you, you'll have to take a no objection from the investigating authority. All right. And then there's one more condition. Take the requisite permission from the Reserve Bank of India. I'll have to go to the Reserve Bank. So the condition is that for every violation you have committed, first get it regularized from the bank. They will say, all right, you've given the requisite explanation, so we will condone the your lapses of holding $20,000. And that Reserve Bank will also, in the last few lines, would write saying that this doesn't mean that your violation is compounded. Go to the compounding authority and get the violation compounded. So, in any case, Reserve Bank is the supreme authority, where before you go for any adjudication mechanism or for compounding, first thing you will have to, one more thumb rule which I think you will all have to go through is, what is the violation and where should I go to regularize it? That is something which you have to invariably find out and exercise with your experience, with your expertise, that these are the violations which somebody has committed, and they will have to first get the violation permitted with these authorities. Is there anybody who's, I heard something from right. The compounding is where the finality is reached for a violation. There are 2 types of violation again. One is the procedural violation in terms of technicality, like you have not filed certain returns in time. There are violations where the sections or rules or provisions of the law is violated, other than the technical violation. So these are the 2 violations for which either you can go for adjudication or you can go for compounding. The question here is, these violations are something which the law permitted you to do, but you are violated technically. For that, you don't need to go to Reserve Bank for getting a permission. A simple example is this. FDI, you've received an FDI where the requirement is for you to issue shares within 180 days. You didn't issue shares within 180 days. You issued shares after 180, the 200 day you issued a share. What is the requirement under the FDI regulation? The requirement is if it is beyond 180 days, you take permission of the Reserve Bank. You didn't do it. You already issued the share, and you have got to file FCGPR. The FCGPR also you file after 200 days. For that filing of FCGPR, it's only a technical delay. For that, you can find out what is the value. You can go for compounding of that violation. But what will happen to your requirement of taking a permission from the Reserve Bank? So for that, you'll have to go to the Reserve Bank, take their permission or a condonation for having issued the share beyond 180 days. Then you file a compounding application for 2 violations. You'll have to be very careful. Again, your compounding application has to clearly say what are the violations you have committed. That's one big problem. You would have listed 2. The RBI will say another 3 violations are there. If I explain what is my violation under the compounding application, Reserve Bank will not accept. In the application, they would say clearly mention which regulation, which sub-regulation you have violated. Only then I will compound your I'll compound the I'll see your application is valid, then I'll compound it within 180 days. So the contravention, as you said, is this. The technical violation is something which has said the FCGPR not filing within that time. There are 2 components in the same transaction. That you will have to ascertain. Now, I will come to the compounding regulations, the brass tacks of compounding regulations. Section 15 deals with the powers of compounding. Read with section 13. What is the what would ensue if there is a violation? Under section 13, the penalty will be up to 3 times the amount involved. Can be the penalty for any violation under FEMA. If the amount is not quantifiable, the penalty can be up to 2 lakh rupees for a violation. In case of a continuing offense, for every day's violation, the penalty can be up to 5,000 rupees per day. So this is the end result of the violation, whatever has happened under the Foreign Exchange Management Act. It can't go beyond that. That is, if the violation of 1 rupee, the maximum penalty can be 3 rupees. That is what the provisions come up with. Now, if you go for compounding, what will be the benefit you would probably get? What is the benefit of going for compounding rather than going through we can also go through the whole process of getting the violation adjudicated. Finally, the penalty is only 3 times. You'll have to decide between the devil and the deep sea. Compounding, you'll approach RBI. Adjudication, you'll approach Enforcement Directorate. So you'll have to decide which one you want to choose, which authority you want to choose to get your violations settled. Huh? Obviously RBI. And that RBI is also now, I will tell you, these are all the problems. These things, it's quite easy. You'll all understand if you go through it. As Vivek sir said, the practical problems, you'll have to deal with the practical problems. You have dealt with the practical problems. You discuss those things with the participant, is what Vivek said. Now there is a big fight between the RBI and the ED. Why, I'll tell you. There is a problem. Rule 6 and Rule 7 of the compounding rule says, if the violation is not adjudicated, adjudication happens under section 16 of Foreign Exchange Management Act. If the violation is not adjudicated, the moment you seek a compounding and RBI compounds your violation, report it to the adjudicating authority saying that your violation has been compounded by the Reserve Bank, and all the proceedings would automatically stop. Right? Section 7, Rule 7 says, in case where the adjudication mechanism has started, both the sections are one and the same. I don't know why they have made it into two sections. And the adjudicating authority is already proceeded with the adjudication, and you have filed the compounding application. The Reserve Bank will communicate with the adjudicating authority saying that the compounding application has been filed before me. So your adjudication mechanism can wait till the compounding is done, because compounding will be done within 180 days. That's fine. So the moment the ED issues the show cause notice, you can go running to seek a compounding also, which is the general understanding. The moment ED issues a show cause notice to you, there are two things which are confirmed. That is, he has completed the investigation, and on completion of the investigation, he has issued a show cause notice to you. That is certain. So now the moment I can go running to RBI for compounding the violation, because he is an easier option. ED has clearly told me what is the violation in the show cause notice. It is still more easy for me to file my compounding application, because he has clearly said this is the violation. He has clearly identified the amount involved in the violation. Everything is done. The moment I go to the compounding authority, he will say, take a no objection from ED. Otherwise, I will not compound your violation. The moment I go to ED, you know what he says? He says, having done all the investigation, having put in so much of my hard work, why should I allow you to compound? I will not allow you to compound. This is what I have been facing from the years when when I'm taking up where the show cause notice are issued. If the case is weak, there is no point litigating it for 10-20 years. And why the compounding provisions are there? To buy peace from whatever violation. There are certain violations where you can't litigate, because it's plain and clear. It's open and shut case that there is no point litigating. Going on the full rigmarole of all the appellate authorities, adjudicating authorities. There is no need. They will not allow. And for this, I filed a writ in the High Court. Even after the High Court has permitted me to file a compounding application, the compounding application was filed pursuant to the High Court direction. Still, my compounding application is returned, giving technicalities that there is a serious violation involved. So I will not compound. In one of the case, the department files an appeal before the division bench of the High Court. Said, department has filed an appeal before the division bench, so your compounding application is returned. And the officer tells me that we will not allow anybody to compound the violation the moment we issue a show cause notice. Even though the law provision is there, we will see to it that the compounding will not happen. No, the contempt of court only says consider the application in accordance with law. I will read what all the things which the compounding authority can ask. Read the regulation 9 of the compounding regulation. It says they can ask any information from you. They can ask any sort of a clarification from you. If those clarifications are not given, your compounding application will be returned. All that they do is 5,000 rupees. In any case, they have got you have given them an ECS mandate. Automatically, that money will come, will fall in your bank account, with the application being returned back to you. What will you do? See, the problem here is like, in a spirit of reconciliation, nothing is being done. Because there is an interconnection between the Reserve Bank and the Enforcement Directorate here. There is no provision to get a no objection from the Enforcement Directorate, but unfortunately they are asking for a no objection. ED is saying, why should I give a no objection? If you are going to question that, where do you question this? We have filed a writ, it is still pending. Let me see what is going to happen to that, because these are the things which the RBI or RBI, unfortunately, there are decisions with the RBI, the supreme authority, they can ask for anything. In the realm of foreign exchange, RBI is the supreme authority and no court will interfere. No court will say, why do you want this? No court will ask, why do you want this? This is the biggest difficulty. That's why I cited LIC versus Escort. You better follow. That's what all the courts have already decided. Bombay has decided. RBI is always correct in the realm of foreign exchange law. So you got to be careful. Before the, if the ED commences an investigation, the moment there is a summons issued against a person, if you are able to ascertain what is the violation, make a compounding application, probably there again you'll have to make a declaration that there is no investigation which is commenced. The moment you say that investigation is commenced by ED by way of a summons, then you'll have to, then they will take a report from there, and the ED says, no, don't compound because we are still investigating, your application will be returned back. Within no time, they'll return back your application. So compounding, according to me, is for simple violations like your all the technical violations which have been listed out. But if there is any other violation, you got to be careful. You got to go very early. You yourself ascertaining that you have violated, and then approach the compounding authority. What are the violations which can be compounded? Any contravention of the rules, regulations? Yeah, rules, regulations, master direction, circulars, or any order is issued by the Reserve Bank. So there are two sets of compounding authorities. For all the violations under the Foreign Exchange Management Act, the compounding authority will be officers of the Reserve Bank. Only violations under Section 3A of FEMA, which is called Hawala transactions. In these type of transactions, the compounding authority will be the enforcement directorate, and for all these authorities, the monetary limits are specified. In case of 3A violation, in case of any other violation, and also now the permission is also given to the regional office of the Reserve Bank to also compound violations, and the compounding rules we have clearly specified what are the violations where the regional offices can compound. So when you are making a compounding application, you will have to find out what is the violation and see whether my application is to be filed either before the regional office, or there is one more authority called FED-CO, whether I have to file before them or before the central authority, Mumbai, which is the authority which has got power to compound any violation. Depending on that, you will have to prefer the application. That is there under the compounding rule, which is fairly clear. You can go through it. Because of paucity of time, I will not be going through that. In any case, it's like you only have to go through the RBI website and download that compounding master directions on compounding. Now, what are the exceptions where you cannot file a compounding application? This is again very interesting. The first one, they said amount involved in the contravention is not quantifiable. If the amount is not quantifiable, whatever is in violation, amount is not quantifiable, you can't go for compounding. The only option available to you is to wait for the enforcement director to investigate, to issue a show cause notice, and then adjudicate the show cause notice. What is the amount involved in the contravention? That has not been defined under the provisions of FEMA. I keep giving this simple example. You have got a foreign direct investment of 10 crores. The violation is that you have issued shares within the time limit prescribed under law. You only not filed the FCGPR in time. There is a violation of 1 month. Or reporting requirement is there is a delay in reporting. But everything else is done in time. Now, what do you say the amount involved in the contravention? Because you can go for compounding. I will give you an example. The violations of signal jumper. What difference it makes whether I'm in a Maruti or a Mercedes? That's all, no? See, a person who gets a foreign direct investment of 10 rupees delays it by 2 days. The person who gets a foreign direct investment of 10 crore rupees delays it by 2 days. Why a person who's got 1 rupee has got to have a compounding fine of 10 paisa, and why the person who's got 10 crore should pay a compounding fine of 2 lakh, 20 lakhs for 2 days? This is the biggest problem in FEMA. Like there are a lot of litigation which has happened on this aspect, that what is the amount which is involved in the contravention, especially technical violations. And unfortunately, every one of us has resigned to this fate that we will have to accept that the amount, whatever the amount involved in the transaction, is the amount involved in the violation. And that is what the compounding rules also say. And that's what we are left with, to buy peace with the RBI. And the amount of fine, compounding fine RBI is collecting is huge. You will not even believe. There are a lot of compounding orders which you can see on the RBI website, where somebody has got a huge investment and their delay was close to around 6 months or so. Your ROCTs is nothing in front of them, in front of the compounding fine what has been imposed. I'm only asking this question, why do they want to, the reason why compounding provisions are there? The beautifully it is written under the regulation. It is to buy peace from the department with litigation, and to not to inconvenience the trade. Imagine you get a capital, and if that money goes in to pay the fine or fees, the money would have been used in a better manner in an organization. Why should RBI collect the money? Why should bank want so much money? Why do they have such much of a craving for the technical violation? Yeah. No. See, the punishment is different. That's what I said. What is the meaning of punishment? What does our law say? Penalty should be a deterrent. Penalty should be deterrent for what? For what you have committed. It cannot be a deterrent for somebody who's got 1 crore, where your country was craving for foreign exchange at one point in time. Now, if somebody gets 10 crores, you should be happy that 10 crores is worth of foreign exchange coming. Why should you penalize him more? What is the definition of delay? Yes. There is no definition. There is the requirement in law to do things in a time-bound manner. You've seen from top to bottom under Foreign Exchange Management Act, every reporting has to be done within a certain time.
Or maybe circumstances, the investment is going to happen in next 3 years. Instead of 2 years, it will going to happen in next 3 years, right? And we were declaring that we're going to earn something out of that. Right? So it is postponing from 2 years to 3 years. So is that delay covered into this delay or not? It's not.
It's very simple. Like, this is as long as you receive the money, and the requirement of your all the procedural requirements start from the date you receive the money. It is not based on the promises. Like as you said, if your investment is going to come in a span of 3 years, as and when you receive the investment, the compliance requirements start from the date you receive the investment. For that reinvestment, what you have received. Example, if you receive 10 rupees today, your compliance clock starts from today. If you receive 10 rupees after 1 year, the compliance clock starts after that 1 year, as and when you receive. And if you don't comply within the time frame prescribed by law, that will be a violation. That will all be a technical violation. But if you want to compound that, what I'm trying to push it across to you is, if you receive 10 rupees, then if you have delayed by 2 days, there has to be some penalty for that. I'm not denying. If you receive 10 rupees, the penalty will be, or your compounding amount will be 2 rupees. If you receive 10 crores, it will be 20 lakhs. The question is, both of them have delayed by 2 days. But why is it that somebody has to pay more? What is my thing? That is what I'm questioning, because is this the amount involved in the violation? The violation is very technical. That's only 2 days. Right? You got the point.
Like 50 lakhs or 20 lakhs of that 100 property. Why is that percentage, same percentage is there?
That is why I'm saying, is this the amount involved in the contravention? The RBI is saying yes. But I am trying to say that this should not be the amount involved in the contravention, because the contravention is not about the getting the money. What is the requirement on FDI? The requirement is you should receive the foreign inward remittance. You've received it. There's one more requirement within 30 days, the receipt of the money has to be reported. That also you've reported. And after that, you'll have to issue shares within 180 days. For some reason, it was not possible. And the authorities have to seek an explanation as to why was the delay. And if somebody explains the delay, there should not be any penalty on him. There should be some discretion. I am not denying that. Ask for an explanation why you didn't do it. Because if somebody explains it well, saying there are some really technical, there is some problem, you can take that explanation, right? My concern is this, because RBI is collecting huge amount of money. There is a fixed amount which is being prescribed under the compounding rules itself, depending on the money which is coming. Because compounding is absolutely not possible without the amount which is being quantified. Why should you not compound something independent of that amount and say only for a few days? This is only oh, that is not possible. That's okay. I will. What I'm giving you is like a food for thought, because your client will really suffer. I feel bad because for a few days of delay, they should not pay so huge amount of money. That's the only thing. Why should they not amend your compound? Because laws are simplified. Your foreign exchange laws are simplified to such an extent. And why do you keep so much of a price tag on the procedural requirement? That's all I'm saying. There's a huge price tag on a procedural requirement under FEMA. If you don't do it, you're facing the government. No. I'll come to that. See, this thing, I'll come to that, because there are certain violations where the amount is more or less specified in the master direction, the compounding rule, where they said they have given what is known as a grid sort of a thing, where for all the technical violations, what is the basis of computing your compounding amount. That is very clear. If the violation is not technical, if it is a non-technical violation, then there are certain yardstick which are with the compounding rules itself provide, saying that what is the benefit somebody has got out of this violation. That benefit has to be deposited back. Okay, they will take back whatever is the benefit which you have gained, or whatever the loss which is occurred to the government by you violating the provision or the rule or the regulation. So this is another way of compounding, where it is not a technical violation which cannot be fit into the grid which is provided in the compounding. I'm not getting into the specific, because that is clearly provided in the compounding master directions. You can go through it. So I'm discussing on certain other general aspects. That's it. So that I will put these things into your mind, and probably you will also start thinking about it. So all that is clear. That compounding is of two aspects, as I've said. One is technical, the other is non-technical, and depending on that, you have to make an application. The amount. If the one more thing is like similar contravention. If the contravention is compounded and the same contravention is done by you, in another 3 years, you can't go for compounding. Once you compound a certain type of violation, you cannot go for compounding for the same type of violation in the period of 3 years. After 3 years, if you commit the same violation, then it will be a fresh violation. The old thing is forgotten, right? It is a fresh violation. Time limit starts now. So every 3 years, you can commit the same type of violation. It will be considered a fresh violation. Okay. And then if you have filed any appeal against the order, then even in those situations, that you cannot go for compounding. Compounding is what? Compounding is on a principle that once you make an application, whatever the violation involved, you have completely accepted before the RBI that I have done this violation. I have no argument to make. And there's one more important thing: when you make a compounding application, you can never be argumentative in a compounding application. Even a single word which suggests that you are not accepting to a certain thing, they will return back your application saying that this sentence shows that you are not accepting the violation done by you. Change this sentence. And they will say, give me an email. The compounding authority will send an email saying this sentence, will you accept it, or will you want to continue the sentence? If you want to continue with this sentence, your compounding application will be returned. You write back saying that no, we will not continue with this sentence. We will admit our violation. If you do that, then they will continue with your compounding application. So compounding is on a principle that you completely admit your violation. You have no argument to make. Nothing. You will only have to prostrate and succumb before the compounding authority, and then the compounding is done. In your application, be careful. You say, I admit, I accept, I admit, I accept, I admit, I accept. That's it. Nothing else. Right? And one more iteration of the compounding, which is a serious amendment which was done in 2017, where the contravention relates to serious offenses like money laundering, terror financing, or affecting the sovereignty or integrity of the nation. Then you can't file an application for compounding seeking compounding of these types of violation. Who is going to decide on that? And at what time somebody says that the contravention relates to money laundering? Because I'm practicing the law of money laundering also, I'll tell you how difficult it is to ascertain. How is it ascertained? How will the authorities ascertain that the contravention is relating to terror financing? Or all right, if there is a criminal case against somebody where these things, the FIR is lodged and the investigations are going on, understandable. In case of money laundering, in case of terror financing, now the latest one of the cases, they are now trying to expand this by saying yes, it is and or affecting the sovereignty or integrity of the nation. This is a very broad term. What has happened in my case is one of the I should not say this. I'll have to be very clear while giving the example as well, because I should not. Husband and wife goes to Germany. They have got a lot of their followers of their faith, I would say, and they go there and say somebody who's very old there, and out in Europe, people are very generous in donating money. These people said we wanted to start some big the thing here for children and all that, and they gave huge amount of money to this husband and wife. They came into India. With that money, they purchased a very prime land which now is near the airport. Government found out that they got 60, 70 lakhs or a crore or something like that at that point in time. And they went on to purchase agriculture, they purchased land. All right, that's a violation. There's a serious violation. They found out that they got money and they invested it in the land. So the show cause notice was issued. Two things: for violation penalty, for having invested the money in the land, for confiscation of the land. So I said, all right, if that is it's a simple violation which is compoundable, I prefer an application for compounding. If compounding is done, if the compounding fine is paid, the land will be saved. Because a compounding authority does not attach land or property. They only impose compounding fine. So I said, immediately ED and the RBI woke up. They said, my God, if I compound, then the whole property will still be kept by them. They went on giving all sorts of excuses. The RBI, twice my application was returned. In the meantime, I wrote specifically to the adjudicating authority saying that don't adjudicate my matter because I have applied for compounding. What the adjudicating authority does, the moment the application is returned, he calls me for a hearing. Within next 3 days, he passes an order. He passes an adjudication order imposing huge penalty and confiscating the land. Now, what does the provision say? They read the third one. If the contravener has filed appeal before them against the order of the adjudicating authority before anybody, special director or appellate tribunal, you can't go for compounding. Now, if I'm left with this order, within 45 days, he will come for recovery, and within 90 days, I have to pay the money. And the property, whatever is attached, automatically it will vest with the government. If I file an appeal, I can't go for compounding. Correct. I file a writ in the High Court saying that quash this order. I've already returned to the adjudicating authority not to adjudicate, but the RBI has returned back my compounding application on a technicality, which technicality I will be willing to comply with. What is the one other technicality? They say go to the government and get the violation regularized, taking the permission, saying that we have invested wrongly. Now, High Court says, yes, what you're saying is right. I'll quash this High Court, I'll quash this order, and I will ask the compounding authorities, direct the compounding authority to accept your compounding application. Against this order of the High Court, there are 2 orders passed. In one of my other client case, they've accepted the compounding application, they've done something. Because this involved huge chunk of land, the department files a writ appeal. In the meantime, I file a compounding application before the RBI. RBI says, your compounding application is rejected. Why? Because I've already challenged the order of the single judge in the High Court, so your application is not maintainable. Now I'm faced with one thing. The difficulty is not there because in any case, the adjudicating authority's order is quashed because that is no longer existing in law. Now I have to wait till the writ court decides the matter. Again, go to the compounding authority. Still, he will not do it. Till they will take the permit, no objection from the ED office, which they will not give. And now there is the latest decision which is being passed, to my ill luck, where the Bombay High Court has said if somebody has acquired a property like this, it might affect the sovereignty and the thing of the nation. So they are right in rejecting the compounding application. Now they have got a clear-cut case to reject my compounding application, which decision was not there earlier. The Bombay High Court clearly said it might affect the sovereignty or integrity of the nation. So your compounding application can be rejected. My only fate now is to go before the Enforcement Directorate, pay penalty, and completely give up my right on the land. Because what is it that I have gained? I have gained the land from that money what I have received, so that the government will take. If the compounding authority had imposed some penalty, even if it is if the land is worth 3 crores, if they had imposed a penalty 50-60 lakhs, I would have given that money and at least held back that land. Now it's not possible. This was a 2017 amendment. The violation prior to that, but still, this amendment will apply retrospectively. I'll have to argue whether this amendment is retrospective or prospective now. So these are the technicalities which you will face in a litigation, right? As I said, the contravention approval from the government, you'll have to take those approvals. Compounding rules, like our time is till 4 o'clock. I'll take another 15 minutes. The other things I'll rush through because half an hour Vivek sir will take on ECB. So, and no, this is like these things are you can read through it. There is nothing like I'll only guide you to the thing for the regulation. That is you can read through. There is anything which is interesting, I will dwell upon that. This guy, once the compounding is done, they will be discharged. So the information, as I said, that any amount, any type of information can be sought by the compounding authority. Once the compounding application is accepted, the order will be passed within 180 days. After that, within 15 days, you'll have to pay the amount. Once you pay the amount, you bought absolute peace from the violations you have committed. No other proceedings can ever be initiated by any authority. Once the compounding is done, the compounding amount is determined by the compounding authority and you pay the money within 15 days. This is also equally important. If you don't pay the money within 15 days, 1 day late, it means that you have not accepted to the compounding application. The presumption in law is that as if you have not made a compounding application at all. Only in some extreme situations, the courts have said that where people have challenged, saying that the amount determined by the compounding authority was very high. The court, many of us have challenged it in the High Court. High Court said nothing doing. You will have to pay the money. Then we have asked the High Court, sir, my 15 days is over. Please give us some more liberty time to pay that money, which the High Court has accepted and extended it. Only in that event that extension is possible, otherwise not permitted. So as I said, what are the factors which are taken into account while passing the compounding orders, like amount of gain or unfair advantage, amount of loss cost to the department, economic benefit to the contravenor, repetitive nature of contravention, track record history of the contravenor. Like in our criminal case, they'll say, what is he's a habitual offender or not? So all those things will be considered. Now, LSF is one more method of getting your violations, bringing to a rest, I would say. That is provided for all technical violations. The LSF is clearly mentioned in the master directions of for the procedure what you got to follow. Once your violation fits into that the category specified there, then you can pay the late submission fee. If there is a delay in submitting of any of the returns, there is a LSF which is clearly prescribed. If you pay that amount of money, the violation will automatically abate. This is much prior to compounding. Once you pay the LSF, admitting the violation, you don't need to go for compounding also. This is LSF is one step prior to compounding, right? So if you will have to check that as well prior to you going for compounding. If the LSF has to be paid, and if you can conclude all your litigations pretty early, you can pay the late submission fee and the violation will automatically abate. Now, the investigations under FEMA. This is the regular route where the enforcement directorate issues a summons to the concerned person to give all sorts of information under the summons. Now, in the summons, the question will be, 90% of the people who have come to me would ask, they've issued summons, correct, but for what purpose they're investigating, they have not told me. Should they tell you the purpose for investigation? No, because people have challenged it, saying that summons does not provide the reason why the investigation is done. All that provisions of income tax law would apply for the investigation proceedings under the FEMA also. So you are all experts in income tax, so I don't need to say that. So under 131, the notices are issued, summons are issued, read with section 30 of the CPC as to your attendance. And what will happen if they don't attend the summons? Fortunately, nothing happens. They will presume that the violation, that you have no evidence or document, they'll proceed against you to issue a show cause notice for which you can reply. In case of PMLA, if you are not attending the summons, the next thing they would do is to arrest. As far as FEMA is concerned, because it's civil law, there is nothing much the department can do to enforce you to appear before the authority. They will threaten you, no doubt. They will threaten only the managing directors to come with this, otherwise I'll arrest. FEMA has no provision for arrest. And if you don't give the information also, it's left to you. And whatever information he will have, He will collate that information and issue a show cause notice. If he issues an absurd show cause notice, unfortunately, you'll have to live with it. Obviously, when you don't go and cooperate for that investigation, what is commenced, he will issue some crazy show cause notice that you'll have to bear with it. Otherwise, once the summons are issued, you'll have to, it's better you appear and give all the information. The client has to appear. The chartered accountant or advocate has no role to be going there. And I've seen in some of the cases where chartered accountants have gone and given the information and also signed the statement. In 2 or 3 instances where the statements are signed by chartered accountants. This is absolutely not permitted in law. And if the institute gets to know about it, you will surely have a problem. You can't get into investigation unless you are an employee of the organization and the summons is issued to some director or whoever. And the director says, because you know about that information, about financial information, you go appear before the authorities and sign the statement, I will be bound by it. If he gives that undertaking to the investigating authority, you as an employee of the organization can go. But you can't represent your client in an investigation. You can go there and explain, not sign in document, not give any information on your letterhead. That is surely not permitted. Because you will become complicit in the violation or any violation which is done in law. So don't do that. So it's only the person who was summoned has to go. If he is not going, he can depute anybody else, or he can also take time. Invariably, if you take time, they'll keep issuing summons. It's better that somebody goes. And I would say technically nobody needs to go. It's also fine, but it doesn't happen practically because they'll really force your attendance and ask for that information, which you'll have to give. Which you do well to give that information as well. Once the investigation is completed, a show cause notice is issued. The complaint is issued, not a show cause notice. Under FEMA, a complaint is drafted by the officer who conducts the investigation, and he places the complaint before another officer to take cognizance of the violation and issue a show cause notice for commencing the inquiry. There is a very crazy provision under FEMA where, like in normal situation, what would happen? Somebody conducting the investigation will also issue a show cause. Here, a person conducting the investigation will write a complaint, and that complaint will go to the higher officer or the equivalent officer also, if the equivalent officer has got the monetary jurisdiction. For example, an assistant director conducting the investigation file a complaint before another assistant director of enforcement to take cognizance of the violation. If he feels that yes, he has made out a case for conducting the further inquiry, then he issues a show cause notice to the person concerned, saying that why should I not inquire into the violation which has been detailed in the complaint. Complaint is always made a part of the show cause notice. The show cause notice will hardly be a page or so. So both the things attached together, that is the time where your proceedings under the law commences. This is a stage where you can hire a professional like a chartered accountant or an advocate or any other person you can, or an authorized representative, to represent your matter and to argue your matter as to why a complaint should not be taken cognizance of, why the show cause notice should not be proceeded against, why the further inquiry should not be made and penalty should not be imposed, why there is no violation in law according to you. All these are to be will be decided by the adjudicating authority, and adjudicating authority should make an endeavor to decide the show cause notice within 1 year. If he doesn't decide the show cause notice within 1 year, he'll have to give reasons why he has not decided the show cause notice within 1 year. So there is no strict time limit in law, but he can take his time. And the proceedings start there. In case of orders passed by assistant director or a deputy director, the appeal lies with the special director appeals. Any order passed by an officer above the assistant and the deputy director, the appeal lies with the appellate tribunal. One more important feature under foreign exchange management is that if you are filing an appeal before special director appeals, there is no requirement of pre-deposit of penalty. If the assistant director or deputy director imposes a penalty, and you are to go in appeal before the special director appeal, then the provision does not say that the penalty has to be paid, and then you can file an appeal. There you can file an appeal without paying the amount, but you will invariably file a stay application saying that stay the proceeding. Because if you don't pay within 90 days, what will happen is the authority who has imposed the penalty will have powers to start recovering the penalty or start proceeding for recovery of the penalty. But in case where the orders are passed and you have got to file by a higher authority, you got to file before the appellate tribunal, there is a clear requirement of paying the penalty amount and then filing an appeal before the appellate tribunal. But normally we will seek a stay application, or we'll seek waiver of the pre-deposit on one ground. The proviso says under the Foreign Exchange Management Act, if there is undue hardship, then you can seek a waiver of the pre-deposit. Undue hardship is on two counts. One is on financial hardship, the other is the merits of the case. If you have a very good case, or you can argue that, see, I've got a very good case, why do you want me to pre-deposit that penalty? Or you can argue that you've imposed a huge penalty on me. I have no financial wherewithal to pay that much amount of money. Look at my balance sheet. So kindly waive the deposit of that money and hear my matter on merits. The application you invariably file. So the first step which the court will take, the tribunal will take, is to decide on your stay application, whether you have got to whether they have got to stay the complete amount of penalty, or they want some amount of money to be deposited by you. Even in income tax, in all your proceedings, you will pre-deposit some amount of money as whatever is the amount which is disputed by you. Here also the same thing is done. If you don't deposit that money as directed by the appellate tribunal, your matter will not be heard on merits. Your appeal will be dismissed for non-prosecution, for not following the stay directions or stay order. But that before special director, there is no requirement. The proceedings will in any case go on and the matter will be decided on merits. The order passed by the appellate tribunal, you can go to the High Court on an appeal. After that, the appeal will be, after that, this specially petition before the Supreme Court. This is the mechanism of adjudication under the Foreign Exchange Management Act. I think with that, yes. Which one? There is absolutely no interest on penalty. Like the interest clock always ticks in terms of the duty or a tax. In case of penalty, there is no interest. This is what he brought me to the interesting, Vivek brought me to an interesting point. I keep telling my client, look, he has imposed a penalty of 10 lakhs. All right. All you can do is, if there is a stay granted, you start keeping that money in some FD or somewhere. The thing every year, your litigation will go on for a minimum of 20 years. Even after 20 years, your 10 lakh will look like 10 rupees. I have an appeal filed before Special Director Appeals 6-7 years ago. Not one. Quite many. My office is filled with cases, files, unfortunately, that they're not getting disposed. So now I was thinking that I'll have to charge all my client holding charges of the file, because I'm holding the file for the past 10 years. So that is the difficulty. In any case, there is no interest, nothing. The quantum of penalty remains the same. Push it. Because money lose value, no? You can earn that money. If you pay today, what's the point? So this is what the cases are weak. This is what is happening. The advocates are known to buy time, right? Advocates know how to buy time in the court. Advocates will never complete any litigation in time. So some pretext or the other. The appellate tribunal, where I file appeals, somewhere in 2016, almost now 4-7 years. My stay applications are still not heard. And I'll tell you one more reason why it happens. Under FEMA, there's only one appellate tribunal constituted which sits in Delhi. For the whole of India, the jurisdiction is only with one appellate tribunal which sits at Delhi. Can you imagine the number of cases which is pending before them? And today, if I take an adjournment, you know, the next date what they would give it given 2024. And that appellate tribunal has got jurisdiction of 3 other laws: PMLA and NDPS, Narcotic Drugs and Psychotropic Substances Act, and another law. 4 laws they have jurisdiction, 1 court hall, and we have no place to even put a foot there. I go very regularly. We have no place to even put a foot there. Now there are new courtrooms which have been done. Now it's okay. Otherwise, there's a time where it was very difficult to even sit in the court. It would be filled with files everywhere. That is never there, Sidli. I don't know. See, the thing is, if there was an intention to close, they would have had some 6 or 7 tribunals in all the jurisdiction. They could have done it, right? Which one? So, overseas direct investment, see, this is my experience, like ODI, resident individuals. I was like always on the, my advice was individuals cannot invest. And there were certain councils in Bombay where they took a view. Now the portfolio investment is clearly defined. They took a view that individuals investing in a company outside India where his investment is less than 10% in a private entity, that is portfolio investment. I said, how? Portfolio investment, as I see, is as simple as this. It's a speculative investment where in the stock exchange somebody purchases the share. That's portfolio investment. And how would you presume an investment done in a private entity, even if it is 2%, as a portfolio investment? They used to go under liberalized remittance scheme. They used to invest there and come back. Amendment was done in 2013, saying that now you are permitted to invest under the liberalized remittance scheme. And what is portfolio investment was defined now, saying that this is not what the government understands as portfolio investment. There are umpteen number of investment which was done under ODI in this route by an individual. What they used to go to Singapore. They said it's so easy to start a company there. They used to start and they used to come back. Now, one of my clients the other day, he invested small amount of money. The company is now the amount of profit he earns and the value of the shares runs into crores. What to do? I have no idea. If the government says, if you have done a violation and whatever benefit you have got, and that has to be deposited back, what is it? Crores worth of money, what you earned will go to the government. The government is the sitting partner on all that. In your violation, government is the sitting partner. There was no this thing given to regularize that also. A lot of the windows was provided in a lot of other cases, but in this case, they said nothing doing. If the violation, it's a violation. And one of the councils fought with me. It was pertaining to one of the big time investors here in India who is also politically connected. And he said that this investment is permitted. Can I do this? I said, no, it's not possible. The same route, portfolio investment. And that chartered accountant just fought with me like I said, what do you know? I've already done 220 investment and you're telling this to me. I said that I don't know. I only read this law now. And according to me, it is like this. So the rest is left to you. And he has already put 220 people into that sort of a misery. The difficulty is, as say in FEMA law, you'll always have to be very, very pessimistic in interpreting it. Don't go overboard. Don't plan the transactions if you are not very sure, doubly sure about it. Ask the RBI, because otherwise the law says whatever benefit you have got, you deposit that benefit. Where will you go? And this man has got the share, and now the shares are worth crores. My only advice to him is become an NRI, go outside the country, show that he's earning and earned outside India, go outside the country, live there, because you've got this many crores with you. Leave India. There's nothing much he can do. The day he chose that there is no oversight, nothing, he has invested the money. But so see, that is why you got to be keeping these things in mind. It might look very simple, naive, no? That is saying whatever gains you have had, that is to be deposited. But imagine a situation like this. All your lifetime save earnings, you'll have to deposit back to the government because you've made a small mistake at that point in time. You've put so much of an effort to run that company outside. All right that you went and invested in 10 shares. Now that company, the software company, is worth crores. What do you do? So these are all, especially FEMA, as Vivek said, you got to be very, very careful. Be very pessimistic in your interpretation. Otherwise, you will lose out on it. Otherwise, statement obtained during all these things are like, oh, you would have all read it. Say, can it be laid as an evidence? Statement can be taken as an evidence because any statement given by you is not a statement before a police officer. So all the statement, whatever has been given by you during the investigation, the investigating authority or the department can use that statement against you. Because you've already said that, you only admitted it, can be an argument given by the department, but you can also argue saying that you can't decide a case only on the basis of statement. You'll have to give corroborative evidence to that statement. That is the job of the department, to lead further evidence against whatever I've said. Right? So you will have to be careful. You will have to tell your client not to admit like Satya Chandra, saying that oh, this I have done. If you say you have done, then the matter ends there. It will be difficult for you only to prove. So you tell your client that when you are giving a statement, you just say that I don't know. I will have to ask them, and then I will consult and I'll tell you. This is what is I have forgotten because I have not. I don't remember the specifics of the transaction. It's for him to make an investigation and make an allegation. Don't make his job so simple by admitting everything. But there are certain things where you have no choice, but you have left a lot of footprints and evidence. That is that apart. That's fine. But normally, the investigating officers harass you. You don't need to worry about that harassment if there is a violation of FEMA, because nothing much is going to happen. And only time when you can go to prison is this: if you don't pay the penalty imposed, then the officer can issue a show cause notice saying that why they cannot commit him to civil prison. Civil prison means what? If you are income tax authority, you will get a nice place, you will get a newspaper to read, you will also get a TV to see in the jail. And for that, the ED has to pay the money. Yeah, civil prison means the ED has to buy the slot for putting you in the jail. Because all the costs incurred by the jail authorities has to be paid by the ED. So they will not put you to civil prison. So nothing to it. And what is the thing? If the amount involved is more than 1 crore, if they cannot collect the money, then the maximum time you can be in civil prison is 3 years. After that, over. You can be free. If the amount is involved is less than 1 crore, the maximum time you are in civil prison is 6 months. Huh? Free boarding, free lodging. 6 months you be there, come back. Penalty amount gone. But the provision says, section 14 says, even if you are there in the prison for 3 years or 6 months, it doesn't mean that the money, the penalty what is imposed on you would abate or go. You still have liable to pay. They'll be following you. As and when you have money, they can still take that money from you. That's all. That is all the gamut of foreign exchange management law. Thank you so much. There is nothing much.
You didn't cover that chartered accountants and enforcement directors are our roles, responsibilities. Chartered accountants, enforcement directorate experience of chartered accountants before ED. Practicing chartered accountants. What happens when they go in before ED? What are the circumstances under which they can go?
No.
Chartered
accounting can't go before ED at all because
when they're respondents for violations, aiding, abetting.
The complicity is not in FEMA. It's very clear. Only PMLA there is a problem. If you are complicit or if you help somebody in cycling of the money or structuring the money or layering the money, if you help somebody in evading that money and to structure it to go to some other thing, which you know very well, you can do it. Like a lot of there is a PMLA is a serious law because any person who helps that person or complicit or assists someone.
Quickly, there are 3 or 4 things which we wanted to cover before Ravi sir comes. Ravi is taking the last session on individuals. FEMA is applicable to individuals, LRS and other provisions vis-a-vis income tax also. So he's on his way. And one more thing which we are supposed to cover as part of our session is external commercial borrowings. External commercial borrowings by entities in India and the whole gamut of all the regulations vis-a-vis external commercial borrowings. Before that, 2 more provisions which are vital in day-to-day practice. One is master directions on import of goods and services, only master direction. There is no section under FEMA for import of goods and services. It is a current account transaction. So it is covered under the current account transaction. There's no, you will not find a section for import of goods and services. So all matters relating to import of goods and services is included under master direction on import of goods and services. So project imports, merchanting trade, trade credits, structured obligations, all of it will be there in import master direction. If there is an import has to be settled within 6 months. If that is a bill of entry has to be settled within 6 months. If it is not settled within 6 months, 6 months to 3 years, the tenancy of the bill of entry, it is outstanding, it will be considered as a trade credit, falling under ECB regulations. Above 3 years, if the import is pending, it is an external commercial borrowing, it is treated as a loan. So many times what happens, holding subsidiary transactions happen, holding companies, rather aggregating companies for the group. For example, major laptop manufacturers, phone manufacturers, they have one aggregator somewhere in a jurisdiction of our trading, Singapore, Hong Kong, and all those places where they aggregate stuff, ship to all the manufacturing locations. That aggregating company, especially in garments also, zips, rivets, buttons, all of it is aggregated for global manufacturing. Bangalore is a major hub for that. Almost 8 to 8.5 lakh women are employed in textile sector in Bangalore city alone. So it's one of the large employers. So from last 30, 40 years, since the export-oriented unit regulations came, Gap, Nike, you'll be surprised, other than Bangladesh, Pakistan, Sri Lanka, India, very few garments, Levi Strauss or Lee are manufactured anywhere in the world. Very few leather shoes and apparel is manufactured anywhere else in the world. He'll be surprised, other than these Southeast Asian countries. Aggregators happen in Hong Kong or Singapore, and those aggregators ship to the domestic manufacturer. Domestic manufacturer treats it as an import used for export purposes inside a EOU. Payment has to be made within 6 months. Sometimes they give trade credit extended. That trade credit also has to be documented as such with the authorized dealer. They file something called TREADS, TREADS, or some report with RBI, where they disclose that these are outstanding for more than 6 months, but below 3 years, therefore treated as trade credit. Forms have to be filed with the RBI. Import bill of entry wise. So be careful, external commercial borrowing doesn't only mean currency loan which is coming, wires coming in, agreements entered. It can also be unpaid import bills. More than 3 years, any import being lying outstanding is a ECB. Without a loan registration number, remittance cannot be made. So be careful on settling import dues. Every bill of entry has to be settled. So external commercial borrowing, the major source of all information for us in practice is master direction on ECB, trade credit, and structured obligation. Structured obligation is domestic loan from Canara Bank to our company, domestic borrowing underwritten by foreign parent. If there's an underwriting by a foreign, full screen. If there's an underwriting by or guarantee by or confirmation by payment obligation undertaken by, in case of default by a foreign company, it becomes structured obligation and therefore reportable as ECB. So ECB regulations cover rank ECBs, bonds, debentures, convertible instruments, not fully and compulsory convertible into equity at any point in time, or trade credits and structured obligations. So be very careful when you're looking at the liability side of the balance sheet of a company. Anything which is a liability vis-a-vis a foreign party can end up being a ECB and therefore requiring a loan registration number. It is not as simple as this is an import payable, let it be. This is a obligation guarantee given by foreign company, let it be parent only. No. If anything in the contingent liabilities, any notes are there, etc., that can also be required to obtain a LRN. So be careful on that. Problem comes when you have to pay, when you have to settle. So then the problems arise. Every bill of entry has to be tracked. Our hygiene on bill of entry is very bad. Exchange control copy of bill of entry is like gold. Now it's all electronic formats, but nonetheless, earlier it used to be exchange control copy. It is gold because without which remittance cannot be made. Invoice wise, every year, if there's a important transactions happening, every year a compilation of accounting information is a must of all the import bills which are lying outstanding, bill of entry wise, invoice wise, bill of entry wise, party wise, without which generally audit should not be completed. because it gives a lot of details and a lot of it throws up a lot of challenges, interesting challenges also. Sometimes bills also have inbuilt interest in them. Delayed payment interest. The minute delayed payment interest comes, then it's a loan. So be careful. Trade credit, supplier credit, buyer credit. Supplier credit is where the overseas party is giving you credit. Buyer's credit is you are availing for the group discount for everybody else in the group. Be careful. Any interest component embedded in an import transaction also has to be looked at specifically, whether it's a borrowing, and agreements are required. If you want to make a payment of delayed payment of bills, you need to have an agreement between the two parties. Agreement again on arm's length basis. Once you say arm's length basis within related parties, which means interest, which means withholding tax. So it has wider ramifications. Leaving import bills unpaid can lead to wider ramifications under Income Tax Act also. Bank. Exactly. So exactly. Super. Three more instruments. Very dangerous instrument. One is a letter of credit. Outstanding LC confirmation from bank in writing every audit close, must and should. That can throw up a lot of peculiarities. Second is standby letter of credit, limits. SBLCs are not transaction specific. LCs are transaction specific. SBLCs are limit specific. Up to $100,000 import, up to $200,000 import, standby letter of credit. Those are more dangerous. You don't know what is the utilization. Then there's used to be another very famous Nirav Modi instrument. I forget. Letter of undertaking, LOU. So that is very popular in the diamond industry. So letter of undertaking with unlimited limits for what used to happen. There used to be an import transaction, which means goods, diamonds used to come to India, obviously not owned, processed, shipped back. In the transition, letter of undertaking was given to guarantee the safety, authenticity, and refund, repatriation of the diamonds. So LOU is another instrument. Any confirmation of balance you take on any large client, especially where peer reviews are there, about 50 crores now, 50 crore turnover, 500 crore, I think, for this period. LOU, SBLC, LC, even if it is nil, let them let nil. And get it to Chartered Accountant's office. Do not get it to client's office. Surprising things have happened, or what has happened in the interim. All letter, bank confirmation should come to CA office, not to client office. No original also you can trust nowadays. Better RPID to Chartered Accountant's office. You receiving it, not even your staff receiving it. So things have become lot of cases. Just sift through the Economic Times in the last 3 weeks. I will not say more. What all rigmarole chartered accountants are going through vis-a-vis NFRA. Simple things like this. It's really becoming difficult to practice or difficult to audit. So anyway, imports, exports, okay. Correct, sir. Advance for export has to be settled within 12 months. No. Again, advance for export, if it's not settled within 12 months, it has to be repatriated. It cannot be converted. You have to repatriate net balance. There's no. 6 months to extension for the import export. Export also the extension for you seek an extension because EDX has to be filed. Earlier there was no EDX. You have to file an extension for 6 months, one extension. Next 6 months with a lot of difficulty they'll do an extension. If that is not done within that time, then you can send them. The problem is you cannot convert. And there is one more, if you read the export regulation quickly, after that you can till sorry, sir. Means, sir, converted into? No. Obviously, it will be converted. See, once you get an advance for export, what I mean is, you cannot convert it into equity, you cannot convert it into debt. You cannot do anything with that instrument. Conversion conversion, obviously, you have to do. The minute it comes, you are forced to convert. So it's a forced conversion. So there's no export bill against it. So it cannot go into your EFC account. It's forced conversion into rupee. So unless you are a SEZ. That is what if you not pay, then you don't need to go to RBI for permission of the interest. If you pay, tell your authorized dealer to take a permission of the RBI, then pay. There's no but
Prior,
yeah.
I said prior to it, otherwise there is no documentary evidence for that. Then it's difficult. You have to think RBI. Your banker will not permit you to pay interest if the RBI approval is not taken. Or not.
Honoring your obligation to, yeah, that is, see, it's like, okay, interest as much as it is compensatory, under FEMA, it is agreement based. Parties have to agree in advance. If the parties agree in advance, chances are the bank will not credit your money because they will treat it as a loan rather than as an advance for export. So be very careful. So documentation drives the transaction. Post facto agreement, yes, you can try it, but prior approval of RBI required for repatriation.
So let's assume the party has not taken the shipment and the money is still lying. So the company take a stand that these certificated there was a money shipment and liquidated damages are being extra.
Okay. This happens very regularly in the airline industry. Certifications, all of most of the shipments which go from Bangalore go into Thales, France or Boeing in this thing. We manufacture aerospace, large industry, and it lies there for certification, for validation, and for shipment there. Warehouses are maintained outside India. For you, the minute you ship, your export is completed. The minute there's a EDF or GR or etc. is completed. The second transaction kicks in. The second transaction is non-receipt of export bill. That is a completely different transaction. As far as you are concerned, advance, you have shipped against the advance, squared off the advance. Again, 3 transactions, sir. Okay. Agreed. No, has the shipment gone or not gone? Not gone, then there's no export. So not gone, then obviously there's no export. There's no discussion at all. Obviously no discussion. Gone, in warehouse, not lifted, discussion. Export bill remaining unpaid for more than 270 days, 6 extension, or beyond which seek RBI permission for write-off or under self write-off up to whatever 20-25% criterion. Yeah, but sold, accepted, defective, liquidated damages, another transaction. So each transaction has to be looked at differently. Every stage of the transaction has to be looked at differently. So be careful when you're an auditor. A lot of times when they say, sir, adu export agittu, reject agoyittu, liquidated damages bandide, that itself will not give you the full answer. Hogitta, EDF aita, GR aita, export done. So cancel the advance vis-a-vis export. Second, export outstanding. EXT has been filed for extension? No. Agreement, the communication between back and forth as to payment? Yes. Okay, extension can be sought. No communication back and forth as to payment? Obviously, extension cannot be sought because there's no discussion which you're having. You exported and you don't want any payment for it. So it's a violation, FEMA. So it may go into ED reference. DOE reference will come. Directly, bank will refer to Department of Enforcement, Directorate of Enforcement. They will not even come back to you. Beyond 270 days, if you don't have Form EXT, no extension, Enforcement Directorate reference, bank has the power to refer to see whether this was a Hawala transaction. That I sent something, I didn't get money for it. Why are you not getting money for what you sent? It's a Hawala. Baki bahar se kuch aur mila hoga. That investigation will start. But sent, rejected, liquidated damages import is a completely different legal expenses that can be repatriated. If you court orders against you, obviously you have to repatriate it from India. Classic case, Tata Docomo. Docomo liquidated damages. We had to pay up to $1 billion. India had to pay. Tatas have to pay. So advance for export of services, to my mind, I don't have an answer to this. I have never seen an advance for export of services. Services have to be settled on account. Rendering of service, yeah. Group companies.
They invariably give advance. There is transfer pricing already has cost plus transfer.
Oh,
and because
sorry.
the group companies, they know that they need working capital requirement, they would have.
Angala, sir.
They would have accounted advance towards service. As far as services are concerned, there is no time limit, but it's a law there that you should have rendered service and you should have raised the invoice and accounted. Even that money, if it is beyond the time limit specified, it will either become a trade credit or become a UPI.
Okay, let me step back. Advance for services under FEMA is different from ITES service. I'll tell you why. If I export information technology enabled service, I maintain something called Softex. I file Softex with STP, I get the export validated. It is akin to goods. What service I am talking about for which advance is not a permission? Lawyer, chartered accountant, architect. We render service, we get paid. There's no advance. Whereas I'm in ITES services registered as such in the master circle. Earlier, what income tax circular was there on ITES. If I fall under those categories, I registered with STPI, invoices are getting regularized, advance for export permitted. But if in that sector it is permitted, but for our sector, no service advances service. There's no provision for reaching advance for rendering service. We are also exporters in certain way. So quickly, when you're borrowing, there's a ceiling up to which you can repatriate. Obviously, the principal can be repatriated in full. All-in cost ceilings exist for amount of interest you can pay back. There is ceilings for procurement. For example, I appointed a credit agency for getting myself rated internationally. I appointed a sourcing agent so that he can get me a loan at good rates, competitive rates, consulting. All of this falls under all-in cost ceiling. Benchmark rate plus 550 basis points, max 6 months tenor. How this interest rates work is tenor of 6 months. If you want to borrow in international market, US dollar for 6 months, this is the rate. That becomes the benchmark rate. Earlier it used to be LIBOR, now it's any acceptable rate, internationally acceptable rate is the benchmark rate plus 550 basis point, which means 5.5%. So let's say LIBOR is 3% plus 5.5%, 8.5% on US dollar borrowing, LIBOR for 6 months borrowing, plus 550 basis point maximum ceiling within which you have to take care of all these costs. Some exclusions remain for FCEBs, exchangeable bonds of 2% commission you can pay for sourcing. For convertible bonds, you can pay 4% commission. Beyond which interests also are restricted. Although they may say arm's length basis, there are artificial ceilings which are imposed. And these artificial ceilings itself becomes arm's length because regulations impose this. So ECB liability, there are certain limits up to which you can borrow. Every balance sheet has a limit under FEMA as to the nature and extent of borrowing which it can do. Nature, I mean, it can borrow for working capital, it can borrow for capex. For working capital, there is a lock-in. For capex, there is a lock-in. Generally, working capital is 5 to 7 years, depending on who you are borrowing it from. If I'm borrowing it from a foreign equity partner who holds equity in me, 25% or more, then there's a lower threshold of 5 years. Otherwise, 7 to 10 years also sometimes, depending on whether it's a public financial institution or ranked third-party banks. If and the amount of interest which I can pay or is also restricted, benchmark rate plus 550 basis point. How much I can borrow is again restricted, 1:4 maximum. So debt equity ratios also have to be managed. Debt equity ratio, what is equity is? Equity plus paid up capital, rather, let me say paid up capital, not face value. Paid up capital plus free reserves are considered towards equity. Debt obviously is the amount of external borrowing. Nowadays, there are INR denominated borrowings also. For example, I can borrow based on INR denomination. I will borrow 1 crore rupees. It may be $100,000 today. Tomorrow, I will repay 1 crore rupees. It may end up becoming $120,000. It may become $80,000 depending on conversion rate at the time of repayment. That is also possible. INR denominated ECBs are also now possible. Masala bonds are a very good example of it. GAIL and all these public sector companies raised thousands of crores on this masala bonds because the liability is frozen. If you are a export earner and you have dollars, earlier you should tend to go towards dollar borrowing. If you are a rupee earner, ideally you should go towards a rupee borrowing because there are large companies in Bangalore, very big names in the flower industry and all that, who borrowed at 32, 34 to the dollar, had to repay at 60, 65. That itself collapsed them. Last 5 years, 60 to 80 on whatever saving you made on interest, because obviously ECBs are less cost effective as in the current account because interest rates are lower, but you may end up losing it on capital repayment. If you borrow at 60 and you have to repay at 80, That itself is a 20% depreciation. Yeah. So be careful. So whenever you're if you have a natural hedge, you have EFC. For EFC balances can be used for prepaying ECBs. So if you have EFC or export earner, you may think of what do you say, external commercial borrowing. Okay. How many of you know what do you think will be the cheapest borrowing Indian companies have done in the history of India? I can proudly say I was a part of a transaction. ONGC borrowed at 3.4%, tenor of 10 years, 36,000 crores. Oh. Oh. Our entire production was dollar denominated. Oil is dollar denominated. So we got it at 3.4 to 3.6%. 36,000 natural hedge. So hedge works. Unnatural hedges, for example, go to the bank. Beyond 12 months, they'll not give you a hedge instrument. No bank will take the risk beyond 12 months, and that will be very expensive. So be careful. So if you have a natural hedge in terms of dollars, think about this. If you don't, I can argue. This itself will kill you. Borrowing itself will kill you. So yeah, this is what I was alluding to. Minimum average maturity period up to $50 million, it's 1 year. And if it's a foreign equity holder, working capital loan up to 5 years, you can extend the tenure. So I'll just stop here. So he's just come here to remind me to stop. No, so equity to debt ratio we mentioned. Ideally, it is one is why I say 1:4. If you have domestic borrowings in the balance sheet, no domestic lender will let you underwrite or pledge assets towards a foreign borrowing unless you've cleared off your domestic. NOC from local borrower is a mandatory. If you borrow from banks, financial institution other than foreign equity holder, NOC from domestic for pledging any instrument, including your securities, including your land or anything you pledge in favor of your overseas lender, NOC from domestic borrower is required. So be careful on that. ECB obviously can be parked outside pending utilization. Parking outside has to be in instruments which they have specified, rated instruments. So there is some Moody's rating, there's some Fitch rating, and another rating is there, AAA B and all that. So satisfy those ratings, those instruments you can invest in. Otherwise, you would necessarily bring it into India and keep it into India. You would rather keep it outside India till such time it is required, and ECB2 CS is required to certify the balances outside India. So confirmation of balances also have to be obtained before signing of ECB2 for dollar balances maintained outside India. ECB2 is a monthly return for compliance with EC, external commercial borrowings. Be careful on obtaining actual confirmation from the banks overseas. Yourself directly to your office. There's a large case, where confirmation of balances were not paid attention to, became a major issue. So be careful on confirmation of balances. Large transactions, be very careful. Otherwise, LRN, obtain LRN, loan registration number, prior to drawdown. Drawdown and then going and getting LRN, impossible, compounding, and sometimes it could become, a reference to ED, if there is no agreement backing it. And some financial institutions lending in India have origins in jurisdictions which are not permitted. China, for example, micro lendings, small, a lot of monies come into Bangalore-based companies from origins which are, troublesome. Don't borrow from those unless you have a LRN registered. If you don't have LRN registered, you borrowed and you go back and say, this is the party I'm borrowing it from, KYC fails, you're in trouble. A lot of these online apps which raise monies for you, for good companies, solid companies, startups are in trouble because of this. So be careful of KYC, obtain KYC, obtain LRN, then borrow. Refinancing of ECB permitted, obviously, rollover. Conversion of ECB into equity, obviously permitted. Partially, fully, both can be done. Security, immobile asset, mobile asset, securities, corporate personal guarantees, all are permissible. Trade credit, we talked about. Structured obligations, we talked about. Sir, I'll stop here. Sir. Okay. Three restrictions, sir. Sectoral, as long if there is a sectoral cap, obviously you have to follow that. If there are sectoral conditions, obviously you have to fulfill those conditions before you convert it. Once converted, ECB2 has to be filed for repayment. FCGPR has to be filed for equity issue. ECB2 has to clearly state on the top, manual in writing, saying that partially converted USD this much or INR this much into equity. FCGPR should clearly say manual in writing, rather now it's all firms database, but cover letter, tapal with bank saying that this amount of equity has been converted into, rather debt has been converted into equity, these many number of years, valuation certificate attached. One more thing which I would still recommend to you is compilation of accounting information of what was the balance of ECB, what was the interest outstanding on the ECB, how much of a balance and interest have been converted into equity, what is the equity status prior, what is the equity status post, all of this in compilation of SRS 4410 certificate to the banker. Otherwise, it will come back to haunt you after 5 years. So, thank you. Done, sir. Quickly, if you are a holding subsidiary, limited risk service provider, transfer pricing agreement, cost plus 20%, ECB is fantastic because everything is insured. If interest is more, cost plus 20% will take care of it. The repayment has to come, it will take care of it. If not, ECB, be very careful unless you have a natural hedge in dollar earnings. Otherwise, don't touch it. Don't touch it. Chala.
Even though foreign exchange laws have moved from criminal laws to civil laws, we chartered accountants need to be selfish and do not hesitate to call spade a spade and have full working papers like engagement letter, letter of representation, etc. Caveats which we need to take care of compulsorily and save ourselves from regulators' questions in future. A very well knitted topic with cross-border loans, ECBs, was very well built upon by ECA Advocate Chidananda, sir. A round of applause for that session. Thank you very much for your time and effort, sir. On behalf of members present here and all the managing committee members of Bangalore branch, we would like to hand over a memento to the speaker. Can I request C. Pramodar Hegde, Vice Chairman, to do the honors? Thank you, sir. Now we'll break for tea and reassemble sharply at 4:25 p.m. For next session by CA Ravi Jain, sir.